at UCLA. And he also received his law degree from the University of Oregon in 1997, and then became a member of the California Bar in 1997. And Cary's also been a real estate broker, and he's currently serving as a director on the Congress of Neutrals. I think we've all had experience with them. They're a fantastic group that help people settle small claims and unlawful detainers, restraining orders, etc. Here at the courts in Contra Costa County. And Cary also volunteers his time as a discovery facilitator and as a mentor at De Anza Law Academy, as well as a family law contempt mediator. Paul Chandler is the founder and CEO of Property Sciences. That's a national appraisal and appraisal management company. He has his MBA in real estate and finance from Haas School of Business, UC Berkeley. And he has extensive experience as an expert witness in all manner of real estate disputes, including construction defect, non-disclosure, water damage, soil movement, intrusion, border disputes, partnership, and third-party malfeasance. He is a national expert on automated valuation models, and he's developed damage models across all types of subdivisions and large tracts of land. And so he's obviously going to be an invaluable resource for many attorneys, I think, listening today. So with that, I'm going to turn things over to Cary.
Hello. I'll share our screen a moment here. As far as the organization, I saw there was a question. I'm going to handle the law of damages, which is going to be the first part. And then Paul is going to discuss the valuation methods and case studies, which will be the second part. The outline that I'm going to share will be, and let me start the share on that, is also going to be emailed to you afterwards. So hopefully that addresses any questions as to the manner we're going through it. Hopefully everybody can see this all right. This is our outline. Law of damages, and specifically, we are discussing damages in the context of construction defect cases. The law of damages obviously is pretty expansive, and within CD itself, it can get very convoluted very quickly. For those of us that have been practicing for longer than we care to think about, there's some semblance of rationale to how it seems, because we recall the mess of litigation prior to SB 800 and the constant evolution of law, and still think of the SB 800 Right to Repair Act as this new thing that we are dealing with. As I looked at it, I realized, no, it's been 20 years. So it's not the new thing. Very briefly, there was a case in 2000 called Oss, and it came down from the California State Supreme Court, and Oss really limited damages in construction defect cases. Essentially, Oss said there is no right to damages if the sole damage you suffer is economic and there has been no damage, actual damage to date. So Oss said, you discover that there's improper flashing under your windows, i.e. every construction defect case ever had, and it's leaking, but no resultant damage has occurred, you have no lawsuit. You have to wait until it actually occurs. And at the same time, Oss also said, if you, the legislature, doesn't care about this or doesn't like this, you should fix it. And the legislature did. And a lot of input was had by both plaintiffs' attorneys, defense attorneys, developers, in fixing it, which the result became SB 800. And while SB 800, Right to Repair Act, became a very good framework, it also left a lot of questions, as is often the case when you have a systematic overhaul, as to what is the law, because within it, some common law was left. So that's sort of the overall framework. I'm going to delve into this a little more specifically as to individual damages and construction defect. First of all, who's going to provide the testimony regarding damages in a construction defect, and also if it's a failure to disclose case in some cases. There are really three specific categories of people that I classify that are needed in every one of these cases. Two of them may be combined in one person. The first is you need a construction expert. You need someone with significant knowledge that can go through, look at what the scope of the defects are, lay them out, do destructive testing if necessary, and develop the full scope of damages as well as a scope of repair. Then that person may hire another person who does nothing but costing. They may be a construction expert that has their own construction company, or the person who's done this scope may put it out to bids with multiple other providers based on a scope of repair. That there frames out, from a plaintiff's perspective, your cost of repair damages and your cost of rehabilitating the property. It also, for the defense, helps them frame it out. Oftentimes in CD cases, everybody knows they get settled well before trial. Expert disclosure in CD cases and the Civil Discovery Act really don't fit well together. The simple fact is, in a true CD case, experts are known almost from the get-go. They're out on site, information's being exchanged, which is good because a lot of times the only argument is not what's the damage, but how much. And that helps a lot of these cases resolve. The other side of the case, or the other expert you need, is an appraiser. And that is, what's the diminished value of the property? You have to have both. And while you could try to get away with one, as I go through how you measure the damages, you'll see it's very problematic to do so. The reason being, you may not know until you're at trial and your judge says, this is the measure we're going to use, which expert's testimony is actually going to be the one in front of the jury and or judge, or perhaps both. So you really have to get both experts lined up in adequate time. The CD person that is doing the scope is much earlier, but you need to give your appraiser time to have time for them to review the reports of the construction defect expert, as well as their cost of repair estimates, because that is going to inform them somewhat. All right, so what is our proper measure of damages in construction defect cases? There is a case that everybody needs to read for CD. It's called McMillan Albany versus Superior Court from 2018. It's California Supreme Court case. I've attached a copy to the materials you're going to get. And the reason this is important is because it lays out the history of OSS. It goes through SB 800, but also goes through and says what common law damages are still in effect and what common law causes of action are in effect, and the interplay between SB 800 and those common law causes of action. And this is important because there were some prior cases by appellate courts that were inconsistent with where McMillan came out. And it was kind of a mess for a while. The second case you should be aware of, but isn't as necessary for reading, is the State Farm General Insurance versus Oettinger. And what it did was it took the holding of McMillan and it looked at it in the context of a product manufacturer defendant. McMillan really concerned a builder. Keep in mind, construction defect cases, there are causes of action for essentially what is strict liability for product defect. And those continue to exist. So you have somebody who designed a defective window in a tract home. It's a product defect case in addition to the defective installation. So again, you have to really factually look at the scope of your case to see what are your causes of action, what are your potential damages. So damages in residential properties constructed after January 1st, 2003, aka SB 800, or Right to Repair Act cases. Civil Code 943 and 944 spell out what damages are recoverable. And the wording of them gets a little bit confusing sometimes. That's what the entire McMillan case kind of went through. I don't like to look at those stats, the language of that, because it's really hard to follow. I like to look at the Casey because I'm like a juror. I'm not the most intelligent person in the world, but I can follow a checklist. And Casey 4571 lays out what are the damages. Under SB 800, you're entitled to recover the reasonable value of repair, i.e. cost of repair. The cost of resultant damage, that's B under Casey 4571. So window leaked, it caused dry rot, dry rot's covered. The reasonable cost of upgrades. So C is, turns out, oopsie, didn't quite meet code with how we did the work. We need to repair it to meet code now. That cost is covered. Cost of removing and replacing the improper repairs. Reasonable relocation and storage expenses. That's important because if the repairs are significant enough, the owners of the property may have to move out. They may have to store their property. Lost business income, but only if the home is a principal place of business. This is probably going to become a bigger issue in cases going forward because a lot of people are now solely working out of their remote office, i.e. their home. Next, cost of investigation, i.e. expert costs are most likely recoverable. Then there is the important limitation in 940 in SB 800 cases, and that is the right to reasonable value of repairing any defect is limited to the lesser cost of repair or the diminution of in current value of the home caused by the defect. So this is where you split. You have your expert that talks about cost of repair. You have your appraisal expert that talks about the diminution in value. You need both of them. This limitation applies carte blanche in detached single-family homes. So there's your little box there. If it's a detached single-family home, it was built after January 1st, 2003. This is your limitation on damages. It's the lesser of the two. Then we go to non-SB 800 cases, i.e. commercial property and residential property constructed before January 1st, 2003. I should have an asterisk for the residential property constructed before 2003. I can't see there being any new cases on those, but I have been wrong before, and who knows, maybe there's something out there that's been told by some other subrogation action for the last 10 years where the statute of limitations still hasn't run as to a home constructed 20 years ago. But I wouldn't guarantee it. When you're on those cases, the non-SB 800 cases, you go back to your more basic civil code damages analysis. And there are really two separate damages analysis, because you may have causes of action for breach of contract or an express warranty that's been provided to you by the person that constructed the property, by the seller. And under that, you're under what's called Civil Code 3300, your basic analysis, that you get the amount that will compensate for all detriment proximately caused thereby, or which would likely result. As to causes of action for damages for negligence and strict liability on those cases, you are under the standard, the little bit better standard of 3333, which gives you detriment proximately caused, whether it could have been anticipated or not. It's a little more reaching standard, you can potentially recover more damages as a plaintiff's counsel in those cases. Expert cost. You generally, in construction defect cases that sound in negligence or strict liability, can recover your Stearman cost. Those include your expert fees. So in other cases, you have to do 998 offers and things to shift expert costs. In construction defect and negligence or strict liability, you do not. You get those fees under Stearman. Breach of contract, you're probably going to have a prevailing party's attorney's fees and reasonable costs that are going to cover your expert anyways. So then we go to limitations on damages. SB 800, we already discussed the limitation for single family residences under 943B. Now we get down to those non-SB 800 cases. Lesser of diminution of value or cost repairs. So generally, in those cases, the successful plaintiff in such cases recovers either diminution in market value attributable to the injury or the cost of repairs, which is ever less. And that is the Mazzetti versus City of Brisbane case from 1977. Important though, because there's a case called Herringer. Courts have leeway to deviate from that. So the personal exception rule, which is very clear, says that you can get excess of the diminution in value, i.e. if the cost of repair is greater, if the property has specific personal value to you. And that means the view is really special. So you don't want to take the lesser of the value and sell the property at a discount to be made whole. You want to keep that property and rebuild it. You love the view out of the window when you bought it. You want to enjoy that. You can get the greater damages for repair over diminution in value in that case, subject to reasonable limitations. So again, this is going to be very factually driven and subjective. The personal reason exception is also incorporated in SB 800 as the personal use. And so you have to, when you're looking at SB 800, you may have an exception for property that you have personal use of, that you personally enjoy, that you may have non-monetary quantifiable reasons that you would rather repair it than to sell it and take the diminution value loss. So again, anytime you have one of these cases, you have to go through a very careful factual analysis of your causes of action and your different types of damages that may apply in that case. So that's kind of your overall summary of valuation. Your most general level of damages in construction defect is going to be the lesser of the difference in appraisal value or cost of repair, subject to a mile-long list of exceptions. I'm going to stop my share here and try to answer any questions that people may have. So the question is Stearman limited to CD or would it apply to failure to disclose? You know what? I don't remember right now. It's been a while since I've read through Stearman. We used to use them in Stearman cost could include overhead and other things in commercial construction defect cases, but I don't remember on a CD, on just a failure to disclose case if they apply. And the reason I'm hesitating is most failure to disclose cases are a breach of contract case. They're not a negligence case. They can rise to fraud, but whether it's a failure disclosed by a builder who sells it to you or a individual secondary owner who sells it to you, you still have those contractual remedies under your normal California Department of Real Estate forms, which say that in a dispute, prevailing party gets their fees plus their cost. So it would be very limited when on a failure disclosed case, you would be looking to Stearman to get your costs for your experts. The question is loss of rental income recoverable when 2-unit property and a second unit was intended for rental and the first unit is not, is owner occupied? Short answer is I'm not positive. I don't think the second unit's covered because the way the exemptions are drafted is the owner is the user of the property. Now, rental income, if it's a CD case, I mean, if you can show that you have that you're relying on it and those tenants are being displaced and you're losing the income, I think that that's a reason approximately caused damage. There's a whole bunch of discussion in some of these cases about what is proximately caused. And again, you have to go through and delve into the analysis for an individual case to see whether it fits within that proximate cause. Steve is, in determining diminution of value, has any case law come down that allows the appraiser to consider stigma damages arising from uncertainty of whether a repair will be successful, e.g. will efforts to stabilize movement and the foundations be successful? I don't know about that, and I don't know, I'll let Paul address as to whether an appraiser can address uncertain damages or the likelihood of a successful repair in terms of marketability of property. I hopefully that mostly answered. It's I wish I could give more precise answers, but again, these cases are so factually driven that everyone requires its own analysis.
Yeah, I'll talk a little bit about stigma, Cary, when it's my turn.
All right. I think you're all there. I don't see any more questions here.
Ready for me? Okay, let me share my screen here. How's that looking? Are we up?
No.
I got to hit the share button. There we go.
Yeah.
There we go.
There we go.
Is that good? The format looks okay. Hi, everyone. I'm Paul Chandler with Property Sciences in Pleasant Hill, California. Marie gave you guys a little bit of an overview, so I won't bore you with that. But I've been doing appraisals for a lot of years now and have seen a lot of different cases. Cary hit on a lot of the really the big topics. On the stigma topic, we like to call it now market resistance. So the term stigma oftentimes isn't as accepted, but if as appraisers, we can show that a property that has unknown work that was done that may or may not be successful, a problem that existed that may or may not come back, and we can show that other buyers would resist purchasing that property. The classic example that every valuation expert likes to use, which is now a national commercial with Carfax. If you've seen that, the two cars, they look exactly the same, but this one had been in an accident and been repaired before, and then they show the difference in price. It's the same sort of concept related to stigma and market resistance. Let's see if I can change my slides now. Your screen sharing. Let's click on that and see if that works. There we go. Okay, so today I'm going to talk about diminution in value. Cary's already hit on most of these topics, and I'll have some case studies for you. You'll notice, and I say diminution in value in practice, and Cary did a great job of explaining the difference between the damages estimate, which is either the cost of repair or the diminution in value. But as appraisers, when we're looking at the diminution in value, we have to do a market derived estimate. We have to, appraisers have three basic approaches to value that they can use: a sales comparison based approach, an income based approach, or cost approach type of analysis. And when we look at the cost approach type of analysis, which is, two sides of the coin, cost repair or diminution in value, we'll have access to what it does cost to repair. And so in most cases, it depends on the specific case, and of course, how realistic the cost estimates are relative to whatever they're trying to fix. In most cases, that's why I say in practice, in most cases, the expert reports that come in from the architect, engineer, contractor and the cost of repairs that come in from the bids is going to be the primary number that we believe is the primary measure of damages. So the argument is, again, back to two identical properties. One has all of these known costs that are all documented and verified that they are going to have to be repaired to bring your property back to its value. We'll use that, and then usually we'll add some sort of management cost even on top of that. So if you are a buyer and you're confronted with two choices, one is a perfectly repaired home, and here is a home that is going to cost you $200,000 to repair it. The number's bigger than $200,000, because why would I buy a home that I've got to repair? Because repairing a home takes work. It takes effort. So there's going to be some cost usually on top of that that will add to that. All right, let's take a look at the case studies. The very first case study, I'm going to call it the geothermal energy home. And one of the things Cary talked about was this idea that something has specific personal value. And this, I didn't plan this case to follow up on Cary's comments, but this case really does exemplify that. This was a home in the Sierra foothills. There was a $250,000 geothermal system installed underneath the house, and this home was supposed to be fully energy independent. It was a 250 was maybe 10% of the total value of the home. So it was a couple $1 million house. But these particular buyers, of all the homes that were available that they could have purchased, they bought this home because they were supportive of having a green home. And you're going to find many buyers in the marketplace today that are starting to move in that direction. And being ecologically sensitive is something that people value. And so there's a question as to whether or not their personal value of having this home and repairing it back to what its original intent was to be when they purchased it was really a big part of this case, and that there was a lot of debate about that. The other thing Cary talked about that relates to this case is the product defect, right? Here's a big product that was installed. There was obviously problems with the product. It wasn't working the way it was supposed to be. It was leaking, lots of issues there. So the value of homes with energy saving devices, we run across this a lot. The question is, did all the solar panels that they put in and the cost that they paid, is the market value of those solar improvements equal to the cost? In many cases, market value will not pay the same value for those types of things, but if there are personal values associated with it, then you have some flexibility there. And again, Cary stole a lot of my thunder, but this concept of, is it to replace it or to reproduce it, right? Are there methods that we could repair and not do it exactly as it was when we purchased it? It could be functional, but it's not going to be the same. And whether or not you produce your cost calculations as to repair it or to reproduce it are issues that you'll need to have with your experts in that particular case. All right, next case study. I like to call this one the rich guy's problems. And I'm sure many of you can appreciate this. There's nothing like having a client who tells you, money is no object. I don't care if I make money on this case. This guy has to be punished. And this particular case was one of my more favorite ones because the next door neighbor, this was a land dispute in the Inland Empire out in the Palm Springs area. That's probably the nicest gated golf course community in the entire Palm Springs Valley. High end, lots of important people living there. And one of my favorite entertainers was the next door neighbor of the property that I was appraising. And because it was on the first hole tee, I got there were no fences because everybody could have golf course views. And as I was inspecting the back of the lot, The next door neighbor, who I won't tell you who the star was, very famous female singer. I walked into her backyard and I could see in the house and I could see people in the house, and my clients tell me, yeah, so-and-so lives there. And I'm starting to feel a little weird looking in her house in the backyard. And he's like, no, she's so nice. Go up, knock on the door, say hello. And I didn't do it, but a fun case. Two guys, they bought this lot at the very beginning of when the subdivision was built in 2005. And one of the buyers was a fairly famous international golf course developer. He had relationships with the builder of this particular subdivision, and he got a discount when he purchased the property, supposedly for some monies that he was owed by the developer. Our client discovered that this discount wasn't really real, and he just basically pocketed an extra $250,000. Our client discovered that, and our client only bought this thing because he lived in the second nicest subdivision in the Palm Springs area, and he wanted a place for his grandkids to go to the pool at this new subdivision. So for $70,000 a year in fees, he goes there 5 or 6 times a year. So money really is no object to this guy. And he wants this guy to be proven throughout the community that this guy stole money from him, and money is no object. So we've been enjoying that. And so it comes back to this issue of responsibility to disclose, right? Did this other buyer need to disclose to his partner that this compensation that he said he was paying, he didn't really pay? Absolutely. And it brings up a valuation question that I'm sure many of you confront, is this retrospective values. How do appraisers, if we appraise something in the last year or two, we know we have lots of data. What do we do now when we've got to go back 15 or 20 years and adjudicate a case when the data is much older? It adds complexity, but it also adds some strength. We had when I was a young appraiser, we had a t-shirt in our office that said, there are no comparable sales. This is an easy appraisal. Not many appraisers agree with that, and I'm sure maybe not too many attorneys would agree with that either, because you need sales and data to draw conclusions. But what's interesting, when there's not a lot of data, what then applies is economics, basic mathematics that we can use to solve that. And many times in these retrospective cases, while the data is going to be dirty and old at that point and maybe not that discoverable, the foundation of economics hold at all points in time. And so oftentimes in retrospective valuations, you have to deploy a lot more fundamental economics than really strong data sets. And so it comes back to, weighting the data. How do you weight the data depending on how old it is and how it relates to your case? All right, let's see what else we got. Okay, that's public service announcement, mortgages or math. This is my own personal slide I stuck in here because I didn't know how much time we have. I'm a big fan of American financial literacy. Americans are not financially literate. They need a lot of help. I would love to work with the attorneys in the real estate group. We also do education through the Appraisal Institute, trying to educate Americans about real estate and financial literacy. All right, case study number 3 is a drainage issue. Where does the water originate from, and has there been diversion? This particular case was a case in Contra Costa County, Danville, Blackhawk. Property owner buys the home. As soon as he buys the home, there's a huge flood in his backyard. Of course, the seller says, I didn't know that my property has ever flooded before. Of course, as they go back in history, they realize there has been. Other neighbors disclosed that there was flooding involved. And then you get into the question of, what did the uphill people do? Have they done anything that diverted the course of the water? And if they make diversions, that they potentially could be more liable for that. Obviously, maybe Cary can jump in here and help me out, or he may know better than me. And I'm sure there's other attorneys there as well. Water has a right to run. And so there's always this question of, is it just natural flow? or was there some action that was taking place by some uphill source that caused the water to move in a different direction that caused damage to you? So there's a lot of issues around that always. And so the past flooding and repairs that have taken place in those neighborhoods and around those areas are usually important things that they'll have us look at if we're in a big flood damage type of case.
The very general rule is you are not liable for water that emanates off your property naturally. You are responsible when you make changes to your property that causes the water flow to change and emanate in a different way onto somebody's property.
Right. And, you know, after people live on a property for a while, they've all, you know, everybody makes changes to the property, and over time things end up changing and getting diverted. And so obviously as a plaintiff, you're going to be looking for those types of geotechnical issues that show that there's been change from the uphill flooding side. Now let's get back. There was a question that one of the previous people asked you, Cary, about this issue of stigma, right? So after we repair everything, is it normal to think that there's going to be some sort of ongoing market resistance? And most people think that, you know, right after the event has been repaired and it's more visible in people's minds, the market resistance is going to be greater. As the property has, you know, been repaired and continues to function without any further issues, as that time expands, then the market resistance is going to get less as time goes by, as new buyers will come in and realize maybe the problem was corrected. So the question is there still some ongoing? My personal opinion, I still believe if something's been repaired versus not, there's going to be something nominal, maybe in some cases. But again, it's when you're comparing apples and apples, one's got a big, you know, blemish on it because it had been repaired. There's going to be something less valuable to that. And, you know, the good and the bad news about this is that those types of market comparison data sets are very difficult to come by and very expensive to produce, right? So if I were going to, you know, if you're going to be in a case and it's going to be a high level expensive case and you believe that there's ongoing market resistance and you want a data set to prove that, that's a very challenging data set because most properties are local and specific. And so as you get data further away, it becomes less applicable. And so again, using economic principles as opposed to market data sets, much more cost effective from a research and a preparation perspective than driving a big data set. Let's see what else we have. Well, you know, construction defects, you know, the question is, you know, how many nails is enough? I'm always, as I read through the architect and the construction experts analysis, we've done a lot of large homeowner association lawsuits. I don't know if any of you guys know the Angus and Terry law firm. They do a lot of that work. And we've done a lot of expert witness work for them over the years. And so I've read a lot of, you know, large architect and engineering reports. And I'm always just fascinated at how detailed, you know, this wall was supposed to have 87 nails and it only had 65 nails, you know, and great detail on those types of large cases. Always water intrusion. Cary mentioned the flashing. There's always flashing issues. There's always some sort of water intrusion. And it comes back to the cost to repair and the fair market value. A little bit about automated valuation models. My background, I spent a lot of time in this space. 3 years ago, I was appointed chair of a federal task force on automated valuation models in housing finance. We've used a lot of automated valuation models for our large litigation support cases. So if you're suing a big builder, pick any of the top builders, and there's a construction defect case, and there's 100 homes or 200 homes that have been impacted. Think about what it would cost just from an appraisal perspective if we went out and got one appraisal on each of the houses. And not only is it costly, it creates a lot of challenges for a plaintiff's team to reconcile maybe all the differences and the nuances between 200,000 different properties and try to keep that analysis consistent. So what we have done is we've developed these models. So we only have to pick and choose a few properties, different floor plans. Once we plug those in, we have the big cost estimates that have been provided by the architects. And then those costs, oftentimes the costs include both individual property costs as well as general common area repairs as well. And so it allocates those costs over a particular area with whatever add-ons we might have for any market resistance estimates that we put into the process. And so you can take larger scale multi-unit litigation and do it much more cost effectively from an expert perspective. Also, I think much more defendable because oftentimes the cost you have to put together an automated valuation model team to dispute it on the other side. It's something you should certainly look at if you have multiple units that you're looking at. I think that might be it for me, Cary. I don't know if you any questions. Anybody has anything else?
You and I either did such a good job talking, there are no more questions, or I did such a good job at confusing everyone that they don't want to ask more questions.
All right. Do we have to keep people here for the hour for the full CE, or how does that work?
Everyone, I would encourage anyone who does have any questions, we maybe should go 5 to 10 more minutes. If there's anything else, so we can be sure to get the credit.
I can actually bring up a kind of an interesting case study in this exact issue.
Great.
A buddy of mine are litigating a case right now that is a combination of a failure to disclose and construction defect case. So the builder constructed this residence in 2013, had it as a rental property until 2018, sold it to our clients at the end of 2018. Mid-2018, the building got flooded due to a sewer or a water main break, which required multiple repairs on the building, which were repaired by the builder. To top it off, our client, prior to the close of escrow, paid $75,000 to the builder for various upgrades. Well, upgrades weren't done right. Building suffers from construction defect issues. The agent who was double-ended the deal was both the made representations about the quality of the work done by the builder, as well as the quality of the premises, and had our clients waive all inspections because, as she referred to it, all the construction was new. And we ended up having to bring in action. Builders moved to compel arbitration as the sellers, failed to post fees in arbitration. After a year and a half of that, we ended back up in state court. Well, we now have a really interesting issue. There has been insurance counsel for the builder as to the construction defect matters that is interested in trying to resolve on behalf of this one party. The builder is an entity who contracted with one of the individual owners, who's the licensed contractor. And it's the licensed contractor's insurance that's in play that's now discussing with us, wants to resolve and can pay us money for the CD claims and the damages, resultant damages from the construction defect. But how do you parse that out from your other damages and also from your other claims? So when I talk about these cases in terms of damages, causes of action, potential paths of liability, where they get very factually driven, that is what I'm discussing. Each of these cases can vary so widely on the facts that you really have to do a close analysis. And in this case, 50 years combined litigation experience, plus the defense counsel has been practicing 30 years, and none of us have a clear answer as to how do we partially resolve just the damages component and still leave liability to this seller as to the others. So there is a question here. Do all these same principles apply to commercial construction defect matters? My understanding is yes, absolutely. In commercial cases, you are still subject to the lesser of the two, cost of repair or diminution in value. The difference is you're not going to have an SB 800 issue required to go through the right to repair and the specific provisions of SB 800 applying, but you are still under that same common law analysis.
Yeah, I thought of another fun little case that we worked on. It was a single family resident, 2-unit residence in San Francisco. And there was a tandem sparking garage in the space that the two owners used. But there was also, they could park in front in the driveway. And there had been some, shared agreements between the two unit owners over time as to how the driveway would be shared. Property gets sold, new owner comes in and wasn't aware as to, how he thought he had full access to the driveway, that other people wouldn't be parking there. And so we get into, that's a non-disclosure issue. And the question is, how do we solve the cost of a parking spot, right? Is that, not a big dollar value case, although, parking spot in a garage in San Francisco can be a couple $100,000, but overall not a huge case. But the question is, how do you find a replacement for loss of a parking spot? Is it as simple as, we go down and we rent one, we buy one, but the nuisance factor associated with now having to park somewhere else is a big deal. Fortunately, that ended up solving, since the total dollar amount wasn't huge. I think they ended up agreeing to continue to pay. They passed some money and continue to let the other party park in the garage, share the space over time. And yeah, lots of border disputes. How many times have you get the non-disclosure of property border, or not understanding where the actual border was? Those types of disputes. Sure, you guys get them all the time.
Does anyone else have any questions to add? Anything they'd like to discuss? Marie, Cary, Paul, anything else you want to add before we end?
It's Friday.
Yeah, happy Friday, everyone. I will, I want to remind you, you will get materials, the PowerPoint and the document that Cary shared. I will send that out to you with your attendance certificate. I'll send that out today, and then you, let's see. I thank you, Cary. Thank you, Paul, so much for speaking today. I think that'll do it if no one has anything else to add.
Well, I just wanted to jump in and thank everyone for attending. And the section, we're planning another presentation in April, I believe on the 17th, if I'm not mistaken. That's right. Maybe I've got the date.
April 21st.
21st. I'm sorry, April 21st. We're still trying to see if we will do this one in person or if there will be a webinar, but please keep your eye open for that. And we've got another presentation coming in April, and I hope to see you all.
If it is in April, it'll be hybrid too. So if you can't attend in person, it'll also be available via Zoom. Okay, thank you, everyone.
Thank you. Thanks for letting us give the presentation.